Welcome to Session 8 of the Delaware Economic Summit. We're here to talk about estate planning, how to plan for the unexpected. To my left, we have the man with perfect hair, Jarrett Morris, Beth Miller, and Gretchen Knight, both from Morris James. So without further ado, have at it.
Okay. So my name is Jarrett Morris. I'm a partner over at Blue Rock Financial Group. We're a financial planning firm specializing in really organization of assets and helping clients get from point A to point B, whatever their goals and objectives are, in the most efficient manner. So with the topic of estate planning, a lot of what we do is working from an estate planning side, bringing in your accountants and your attorneys in order to collaborate and ultimately accomplish your objectives. So, welcome everybody.
I'm going to start the presentation off, or the discussion off, by, we thought we would talk a little bit about a fictional couple and sort of take you through their lives and the different issues that arise that are related to estate planning, which is the topic of this session. I'm a little bit of an odd duck in this panel, however, because I'm not really an estate planning attorney. I'm actually a domestic relations attorney, and to the extent you don't know exactly what that means, it really means that I do all of my work in family court on issues that impact families: divorce, custody, child support, guardianships. I do premarital agreements and the like. But there are issues that come up that domestic relations attorneys can help with that are related to estate planning. And so the first part of the discussion will be that this young couple, we've put them up here on the PowerPoint, Luke and Jen, are in their 20-somethings. They decide they're going to get married, and so that's the first step in their life that they confront as a couple, where an estate planning issue or question might come up. At this point in their lives, at 20-something, the issue is probably more on the minds of their parents than on their minds. And in the minds of the parents might be, okay, well, wait a minute. So Jen is her family has a family business. And Jen works in the family business, and they know that over time, the family is going to want to put some of the ownership of that family business in Jen's name. And perhaps Luke is the beneficiary of certain assets, or is anticipated that he's going to be inheriting assets, maybe from his grandmother or what have you. And the parents may be thinking about, okay, so what happens? Hopefully our children are going to live a long and happy marriage, but what happens if they divorce? And is there anything that we can do to try to help them in the event they choose poorly? I get calls all the time from young people saying, hey, my dad said I have to call you because he wants me to get a premarital agreement. And it's because I have this family business, and he wants to make sure that in the event my marriage doesn't last, which of course that will never, ever, ever happen to Luke and Jen, but in the event it does, that he's not faced with the potential of that family business going elsewhere or being invaded by the other spouse. Well, that's the reason for a premarital agreement, and the exact type of thing that a premarital agreement can help with. Because I don't know how many people know and understand this, a lot of people who come to see me do not, but everything that you accumulate during your marriage, regardless of how it's titled, is marital property and is subject to division in your divorce, and that means everything: retirement accounts, bank accounts, automobiles, business entity interests. Everything that you acquire is subject to division in divorce, because people come in and say, oh, my wife and we've kept everything separate. We have separate bank accounts, we've never commingled anything. I have my retirement, she has hers. But the reality is that all of those things are marital and subject to division and divorce. So the concept of the premarital agreement and the protection that that parent is looking for the child is to say that business is the separate property of the child in whose name it is, and is never, ever, ever, ever going to be a part of what is marital property and subject to division and divorce. I deal with those types of premarital agreements all the time. I draft them, and then I also help to enforce them if that inevitable divorce occurs. And so that's the first step in it. They do the premarital agreement. They've got some protections in place. Their parents breathe a little easier, assuming that they live the premarital agreement and don't put it in a drawer and forget it. But I'll talk a little bit more about that later. But now they're happily married, and the next step in their life is, okay, now what from a planning organization, estate planning point of view. And Beth and Jarrett are going to talk about that.
You want to take an opportunity to introduce yourself?
Sure. My name is Beth Miller. I am the estate planner or an estate planning attorney at Morris James, and I practice throughout the state. In each county, I practice. So I'm traveling a lot up and down the state. But, people ask me, well, what exactly do you do? What is an estate planning attorney? And what I like to say is, well, you know how you've heard that nothing in life is certain but death and taxes? My practice area encompasses both death and taxes. So I handle estate planning and estate administration for Delawareans. And I normally talk about death. So estate planning only when it impacts people that have died. So Gretchen talks more about the divorce aspect. My practice encompasses when people separate through death. So here in Delaware, we no longer have an inheritance tax. Other states do. Maryland has a draconian inheritance tax. We have an estate tax. We also have the probate fee. Who here in the room does not have a will? Trick question. Everyone has a will. You just may not have drafted it. The state drafted it for you. So everyone has a will. Whether or not you want it to be your will, then you really should evaluate what the state puts in. And they don't leave everything to the spouse. It all depends on whether or not you have children, and whether or not the children of are children of the marriage, and whether there are children outside of the marriage. Depends on, or then dictates who inherits what should you pass away. So, here in Delaware, we have 3 counties. The probate fee in Newcastle County is 1 3/4%. The probate fee in Kent County is 1 3/4%. The probate fee in Sussex County is 1 1/4%. That probate fee is on everything other than real estate that goes through your will. Everything. Well, there's no minimum. Everything that goes through your estate other than real estate will incur that probate fee. I have 2 children. I own a home. The likelihood that my 2 children will be able to stay in that home together if they're over the age of 18 is 0. So many people direct that their home be sold, then the proceeds divided. We're an agrarian society here in the state of Delaware. We like our real estate, we like our dirt. So we don't charge a probate fee on dirt. But if I direct that my dirt be sold, it's no longer real estate and that's the law. I've just converted a non-probate fee item into a probatable fee item. There are ways around that, but not without looking at your estate plan and your family. When you set up an estate plan, you want to make sure that when you go to the lawyer, you're comfortable with saying things like, let me see, the last couple of weeks. I've had clients with children that are in prison. I've had clients with children that are fiscally irresponsible. I have clients who are disengaged from their children. So there are all sorts of situations that really should be addressed in your will. That's why they call it your will. So that your will follows what you want. And if you're not comfortable discussing all the sordid details, if there are any, I'm not saying there are some, but let's just say there are some, then you need to find a different attorney, because not every attorney is going to work. And some people like different types of attorneys. I like to hear the stories, because once people feel comfortable telling me stories, I can kind of hear the concerns, and then I can ask questions that can be addressed in the document. So, everything that goes through your will, other than real estate that is directed to be sold, will incur a probate fee of 1 3/4% or 1 1/4%. That's estate planning in a nutshell. Yes?
So with real estate, even if it's directed to be sold, but not sold for another year, due to market conditions, it's still.
Subject to probate fee. Now, many clients say, well, I have real estate in Maryland. Okay, so let's say I, an individual, own real estate in Maryland. I will not incur a probate fee here in the state of Delaware on that Maryland real estate, regardless. I will incur a probate fee on everything else. Everything else includes furniture, furnishings, jewelry, cars, things that you can touch. Things that you can't touch, intangible personal property, will still incur that probate fee unless it doesn't go through your will. So how can property not go through your will? A lot of ways. One is a trust. Beneficiary designations avoid the probate fee. However, second question, if I have a child that's under the age of 18, I can't name them as a beneficiary on any asset. I don't care if it's life insurance, I don't care if it's a 401k, I don't care if it's an IRA. They cannot be a direct beneficiary. People say, well, I didn't. I named my children, but if my children don't survive me, then it goes to my grandchildren. Then you have an issue, because then you have a minor inheriting property, which they cannot do here in the state of Delaware. You can add special provisions in your will, but unless you talk to the attorney and let them know what's going on, then your will isn't going to really reflect the proper procedure. I had wasn't my client, but I had someone come in with an estate. Beautiful trust. It was a beautiful trust. Except the beneficiary designation was her minor child. So there was a disconnect between beneficiary designations and actual will documents. And I think, Jarrett, you're capable of speaking of that, so it has to you.
Yeah, so to Beth's point, one of the things that we find is, so we're certified financial planners. Our practice revolves around financial planning. And I think a lot of clients don't necessarily understand what financial planning is, but how it is different than stocks and bonds or your broker or your insurance guy. What a certified financial planner is we know a little bit about a lot of things. Okay, so how taxes affect your overall investment strategy, or how your estate plan can improperly be set up, or what happens if you do get divorced and have to dissolve your assets. So we know a little bit about a lot of those things, and a lot of times we carry a long-term relationship with our clients and understand their deep, dark secrets, but we don't necessarily know the specific details. And what we try and do with our clients is quarterback and make sure that if a circumstance were to arise, in order for them to prevent when somebody passes away, to make sure that their estate is properly set up, then we walk them over to the estate planning attorney, or make sure they're getting proper counsel from their accountant. And I don't know about you guys, but I'm a visual learner. And a lot of times when people come into our office, they come in with folders and boxes of stuff. They have accounts all over the place. They have wills and trusts that they haven't, looked at in 13, 14 years. Most of the time, the people or their beneficiaries have had grandkids and they constantly want to change it, but they never think that it's now's the right time, or that death could happen to them. So what we do is we say, bring your box in. I don't care what it is. Bring all your information, and we try and put it into a workable format for them so we can start to hand off and delegate to, our estate planning attorney, or when they have a meeting with their accountant, or if we're involved, that now it is in a workable format where they can see exactly what they have. So this is an output from our website. Every single one of our clients gets a website. They can go on, log in at any point in time in the day and see up to the minute information on exactly where their assets are held. So as we go through it, here's where all their assets are. Like I said, when somebody comes in with that box of information, it's interesting because one of the other advisors will sit down and say, tell me everything that you have. Jot it down on a yellow pad. And what we find is after we go through the details, it actually looks very different than what they described. Okay? So our job is to take what they think they have and make it a reality. So you can see how everything is titled matters. So when you go and meet with Beth, or when you go and meet with Gretchen, and you have to separate the assets, as opposed to sitting down with them for 4.5 hours, you can come in here and see exactly what you have. It's a big deal, okay? So here's all the assets they have, here's what Luke holds, here's what Jen has, and here's what they hold jointly. And then debt at the bottom. Okay, so again, organization I think is one of the top priorities from developing a estate plan. Because again, most people come in with that box of information and really don't have a clue where a lot of that stuff is. And I always ask our clients, what happens if you're not here? If you can't find your assets, then how is somebody else supposed to be able to find it? And in the digital world that we live in, now we all have username and passwords to every single one of these companies. Our money's not all held in the same company. Or, we file away those estate planning documents that we did 15 years ago in this vault. Does everybody know where the key is? Not necessarily. So those are the things that we like to drum up questions to make sure that when you do go and talk to Beth, you have the right material, where we're not spending a bunch of time talking or planning around the wrong assets. Okay? So I think a good way to transition on from now we're a married couple, we have everything organized. God forbid, what happens if we wind up getting a divorce? So that's a very relevant topic. Nobody wants to talk about debt, nobody wants to talk about taxes, and the last thing on the list is nobody wants to talk about divorce. But they're all realistic things that occur. So,
Jarrett, can you turn to the page that's the estate flow chart? Back one. Yeah, stay on that page for me. Okay, so initially what I talked to you about was the premarital agreement. What I'd like to talk to you a little bit about now is just the concept of, remember what I said to you is if you don't have a premarital agreement, everything that you accumulate during marriage is marital and subject to division and divorce with a few limited exceptions. And those exceptions are if you inherit property and you keep it in your name during your marriage, it's not marital property and subject to division and divorce. Although for each of these assets, there is some argument that the growth potentially during marriage could be considered marital. If you get a titled gift of property during your marriage and keep it in your own name, it's not marital, subject to division and divorce. Examples of those could be like stock that gets gifted, business entity interests sometimes gifted during marriage are not marital property and subject to division and divorce. And premarital property by its very definition is not marital property and subject to division and divorce. Although, again, premarital property, and this is one of the reasons why people sometimes like to use premarital agreements, is that premarital property, particularly the best example of it is a premarital home if you live in it during your marriage and you pay the mortgage on it, you maintain it, you're creating a marital component to that premarital asset. But if you've got a premarital agreement that says that separate home asset, that home that's in your sole name, is yours in the event of divorce, then it's yours without any portion of it being a marital asset. The thing that happens sometime, though, that I think both estate planning counsel thinks about and financial planners think about is that if you have an asset that's non-marital, like an inherited asset, I had a case like this not that long ago. A woman inherits $100,000 from her mother, passes away. Woman puts, or more properly, husband puts that $100,000 into a joint bank account. That can happen either because the parties do it for convenience. Sometimes estate planners do it for purposes of equalizing marital estates for trust planning. If you put the inherited asset into a joint bank account, you've likely converted it into marital property that's subject to division and divorce. And it's some of what shows up on this estate flow chart, where we can see that it says transfers to spouse. So if what that means is that somebody's deciding to transfer that Barclays 401k and that cash account from one spouse to another, and it was not marital property, that they potentially turned it into marital property. And that's something that is critical to know and understand. And when I present to people, I usually have some financial planners come up to me after the meeting and say, can we talk through that again? I've got to go back to my office and do something. That's a really important thing to think about. Issues in divorce, in addition to that issue, are that people have to think about, everybody has to think about when they're going through divorce, I need to change my will, my estate planning documents, and I also need to be changing all of my beneficiary designations, because failure to do that can result in really unintended consequences. There's a Delaware case where a man failed to change the beneficiary designation on his DuPont retirement asset from his ex-wife to, I don't think he remarried, maybe his children he would have left it to. He never made that change. And when he died, his ex-wife got that retirement asset. I'm guessing that was an unintended consequence, but his failure to make that change was pretty critical. Something to think about.
That happens all the time. Again, that box of statements and stuff that comes into our office, most people don't realize all those accounts that you set up. You know, that 401k when you started at DuPont when you were 21 and now you're 55, and you've since divorced, maybe even gotten divorced twice, and then had 2 kids, you never changed the beneficiary on it. And then you went to Beth and you set up an estate plan, and she created this beautiful trust. And guess what? The 401k plan still goes to your ex-wife or your ex-husband. So there's a lot of things from an estate planning perspective that most people don't necessarily just know the rules and the process behind it. So again, I go back to the drawing board is let's organize this. Let's figure out what we really have, and then make sure that when we meet with Beth, we know that we're going to change it across the board. You know, or like Gretchen mentioned, there's plenty of advisors out there or stockbrokers that are trying to bring all these accounts into one so it's easier to manage. But you just took your inheritance and commingled it with a joint account, and now if you get divorced, it's a marital property, and now it's subject to division. So if you don't organize and put it all into perspective and get everybody in the room, you're probably gonna make mistakes. Because although we all look at the same information, you know, I'm looking at the tax returns, the accountant's looking at the tax return, the attorney's looking at the tax return, but we're all looking at different lines and how it's affecting, you know, our piece of the pie as opposed to the collective picture. Why not get all these people in the room together and then figure out what's truly important to the client, and then make the changes. And that's just that 1 year. Think about 5 years ago, how very different your situation is from even 5 years ago. That constantly happens. So if you don't have a place where it's constantly organized and up to date, most likely your plan is out of date.
For example,
Mm-hmm.
Teddy Pendergrass, when he passed away, his new wife got everything. The son was a financial planner, his partner bought funds, so it's transferred. I know them personally, so I know they're mine. So I was just saying, it's the family's family, so they've been tied up in court, trying to, Teddy Pendergrass Jr. is trying to get some money, the ex-mother or whatever, well, she has it all, so there's a big battle going on. This has been tied up for 8 years. He still has not one cent, and it's tragic.
Yeah.
Even his 3 little children.
Costs are obviously a concern when you're dealing with estate planning, and you see the cost of setting up trusts and things like that. I can tell you it's way cheaper to set it up right from the beginning than it is on the back end when you're trying to map it all out, and the brain that came up with it or developed all these trusts may not be here. So it does create a lot of controversy. So
Tragic.
yeah, that's definitely.
I think Jarrett raises a good point. Even if you have beneficiaries on all of your accounts, you always need a contingent beneficiary. Because I can guarantee you, if I have named a child and tragically that child passes away, the last thing I'm going to be thinking about is, oh, I need to change that beneficiary designation. So just do it now. Add a contingent beneficiary. Second thing that Jarrett raises, which is a good point, is you should review your estate plan every 3 to 5 years or life-changing events. Divorce, marriage, babies, imprisonment, maybe because I'm from Kane County. Just always look at life-changing events. Graduation from college, failure of college. There's just so many things that really should trigger. And what my husband and I do is every, New Year's Eve, we'll just take them out and everything is fine, so stick them back in. But it's a nice time to talk and discuss, will this still work? So you really should be aware of what your documents are and what they are supposed to do. Really important.
From a process standpoint for this couple, I think maybe the next step might be after they've divorced. Maybe they divorce in their 40s. Maybe they've had children, and in their mid to late 50s, they meet someone and they're thinking about getting remarried. So I'm going to circle back to the premarital agreement again, because this is the other tie-in from estate planning to premarital planning. And I see all the time second marriages where the husband and wife, the intended husband and wife, they're both financially secure. They're in their 50s. They've accumulated their own assets. They're both working. They both have 2 children each. And let's say their children are in their early 20s. Well, the intended husband and wife might be concerned about making sure their children understand that they shouldn't view this marriage as a threat, somewhat along the lines of the situation that you were talking about. That the parents often want to enter into a premarital agreement and waive something called the right of elective share. Because in Delaware, you actually, interestingly enough, cannot really, I always talk about it as being disinherit your spouse.
Without jumping through some hoops.
Yeah. So because in Delaware, if you were to just if I were to change my will right now, and name my children as the heirs to my will and exclude my husband, and I passed away, my husband would have the right to stand up and say, hey, I'm the surviving spouse, I'm asserting my right of elective share, and in Delaware, I believe it's still a third.
It's 1/3.
So what the premarital agreement can do is waive that right of elective share. And therefore, each of those intended spouses can leave their estates to their children. They're not leaving to one another. They don't need one another financially if the other predeceases. But they want their children to know, hey, I'm taking care of you. This is a loving relationship. We're going to get married, but you shouldn't view it as a threat. We've got this premarital agreement. We've got this covered, and we're both financially independent. Something I see often, and I think it's a great estate planning tool. So where do we go from here?
So couple just got divorced, now on the verge of being remarried, right? I know a number of things that we look at is Social Security, right? If you've been married for longer than 10 years, you can actually potentially collect on your spouse's or ex-husband or wife's Social Security payment, especially if they were the breadwinner and maybe you had been a stay-at-home mom or stay-at-home husband. There are a lot of components there that you need to look at from an income standpoint. You know, I know how kids are affected from divorces, and then, you know, the division of your estate at that point in time. If you were to get remarried, to making sure that you do talk to the divorce attorney or estate attorney to make sure that as you're moving assets around, you're not disrupting the ultimate goal, which is, you know, maybe getting your kids the money as opposed to the new wife or the new husband. So as the couple ages, do you want to go through some more estate planning?
Sure. I'm the youngest of 6. So, and my mom's a stay-at-home mom. So I had no idea what a trust was until I went to law school. But a trust, which does avoid probate, there are 3 people involved. The first person is the trustor, grantor, settlor, that's the person with the money. The second person involved is the trustee, that's who writes the checks. Third person involved is the beneficiary. Obviously, that's for whom the checks are written. So if I set up a trust, I'm always the trustor. I'm the trustee, and I'm the beneficiary. I can tweak it a bit. I can add other people as trustees. I can add my children as beneficiaries. Upon my incapacity, I can no longer write a check. So I've named a successor trustee. I'm still the beneficiary. I'm still the trustor. If I pass away, I'm still the trustor, obviously no longer writing checks, and obviously I'm no longer a beneficiary. So it also stands in as a will. I jumped through those hoops, I've avoided probate. That's a good thing. If I had been given a pile of money when I was 18, I can pretty much guarantee I wouldn't have had it by the time I was 19. I know very few people where that is not accurate. So some parents like to hold on to the inheritance, even if they pass away. And you can limit the child's access to the money by a continuing trust. And what many people say is, look, you know, my children are still in school, they get what they need, but they don't get what they want. And then you can set up a trust, whether in your will or in a separate document, that allows the child to kind of learn, if their parents are no longer here, how to handle money. And what I normally say is, look, because trusts are taxed at the highest income tax bracket, at a little less than $10,000, it's not cost effective to maintain a trust for income. You spit it out. If you spit out the income, it's taxed at the beneficiary's level, where you have the huge graduation of rates. So it's more tax effective to pass my income out of the trust. And have the children's needs met. Health, education, maintenance, and support, just like you would now. However, at what point would I ask my clients, do you feel that the children should be able to demand what they want? Whether it's the entire trust fund, which very rarely do I suggest. Instead, what I say is, give it to them in thirds. So when they receive their first third, you know they're gonna plow through it. By the time they get 1/2 of the balance, or 1/3 of the original, hopefully they look back and they see, well, what did I do the last time I got this much money? I have an aging SUV, I have some great memories, but nothing else. So by the time they get their last third, you hope, can't guarantee it, they've learned their lesson, that they have some money left for big things. Whether it's, a house or educating their own children or something like that. But you never want to give a big chunk of money to an 18-year-old. Period. You shouldn't. I have a client, one of my first clients when I came to Delaware, who was, I think, 23. Very well-known family, was expecting to receive a huge inheritance. He was going to Merrill Lynch, he was working at Merrill Lynch, doing great, and then he realized, I'm gonna get this big pile of money. Stopped working, got the big pile of money, went through the big pile of money, and now he's got to find another job. He now has, 4 years out of Merrill Lynch, so he can't go back to Merrill Lynch. And times have changed so that he's not readily employable anymore. So, don't do that to your children. It's not a good thing. Not a good thing. And what some people do now, which I've done a lot more frequently, are what we call incentive trusts. So, if children, and I'm not saying that with anyone in mind, but my son Davis, let's just say theoretically that I'm a little worried about his working capabilities. So an incentive trust can match earned income. So the harder he works, the more money he will get from the trust. He can double his income, that's a good thing. If he doesn't work, he doesn't get any money from the trust. So there's kind of an incentive there. He'll match whatever he earns. So the harder he works, the more money he will receive from the trust. There are different strategies that you can use to address your family. Again, you have to be comfortable with, okay, my daughter Annabelle's a complete loon. What do I do? So ask so that it can be addressed. That's it.
So Beth just brought up a good point. So there's a number of different trusts now we can set up. And there's a number of different objectives that each one of these trusts are trying to accomplish. So the incentive trust, so your kid starts working, they could potentially pull the same amount of money out of that trust that they are earning as income. Well, now what are we doing with the investments inside of that trust? So now we come back over to the investment world from our side of the table, and we try and map up an investment strategy that mimics the goal of that trust. Okay, so if your estate planning attorney and your financial planner or your investment planner aren't working together, there's going to be a disconnect, and those investments aren't going to accomplish that objective. Just like she mentioned, if you have assets in a trust that particular person inherited, the trust is at the highest estate tax bracket, called over $10,000. So if it's generating, the investments inside of there are generating a lot of income and you're not distributing that, we're paying almost 40% on those earnings. We should have a different investment strategy in that ultimately matches up with the type of trust that it is. So there's where collectively as a whole, we need to make sure that we're all on the same page. And then we get the accountant involved and they say, oh, you owe a lot of taxes. Well, what could we have done in the beginning of the year to make sure that that potential problem is avoidable? Organization. Any one of our clients can log into their website and see exactly what's going on, and then it allows us to collaborate with any of your advisors in order to best accomplish the objective that's at hand. Who's to say that that trust is going to be the trust that we maintain for the rest of our life. No, change happens. At what point do we go back and see Beth and we set up a new trust? Those are the things that we want to constantly stay on top of, because it's a lot cheaper to fix them in the beginning than when there's a problem.
Beth, I got a question for you. So, deceased parent has a trust, which is going to dictate that their child will receive a third, a third, a third. How does this deceased parent make sure that the child's spouse or loser significant other doesn't get that parent's inheritance, essentially?
Goes to Gretchen.
So you're saying that when the thirds come out, how does the recipient of the third make sure that it doesn't end up in the,
How does the deceased
Oh,
parent
it's
make
deceased.
sure that the child's loser boyfriend or significant other, whatever?
I'm not sure that there really is a way to make sure that happens. I think that the concept around these documents like trusts and premarital agreements and what have you is to help the child, but you can't completely protect. If that recipient of that third says, this person is the love of my life and I feel like the right thing to do is to put this money into a joint account that we're gonna share, then that's gonna happen. I would say that maybe one of the exceptions to it that I've seen are that around family businesses often there are restrictions on transfers of the closely held corporation stock. Like you can't put it in the name of the spouse. But if it's cash, if it's a home, once it comes out, I think you lose control.
I have clients that say, look, I do not like my in-law. I do not like my son-in-law. How can I ensure that he will not inherit this money? And I said, well, then you have to give up on giving it outright to your daughter at any point. Because once you give it outright, you have no more control.
Case in point, my family. My parents were self-made, and my mom passed before she had all the things in her grab, and named all three. I have two sisters, one older, one younger. The younger one's an attorney.
Named all three as executors?
Uh-huh. So, before she was even buried, they confronted me, and my aunt said, you really don't want to deal with it because there's a lot of jealousy here and a lot of money. So my older sister self-appointed herself as the executor and mortgage beneficiaries. She's taking an administration fee from the estate for handling it. And I would just been in the background, just slide along,
Well, that raises a very important issue.
I had like no control.
I have been an estate planning attorney for over 20 years. I can count on one finger the number of times I've named more than one person serving as a fiduciary. The difficulty is, if you name more than one, you need unanimous consent before anything can be done. And the likelihood that that will ever happen is zero.
They acted like everything was hunky-dory, and then as soon as, before she was buried, it was just.
Well, they didn't have the authority to do that until the wills actually
Well,
recorded.
The whole thing is, it was voluntary on my end. It was just like, my aunt was like, do you really want to try to deal with?
That's when you hire a lawyer and you say, I want you to be the bad guy.
I called another attorney, and I was back in the office, and I knew my rights, and I was just like, it's not worth it. So
Well, that's not really a legal decision, but that's a family decision, and it should be
that's
respected.
my decision. So I went to register of wills with them and signed it all over.
And how'd that work?
I've kept my mouth shut. They kept poor representation in real estate because I get no referral fees, no commissions. Fine, I don't do anything with the appraisals. I don't put my input in because it's not appreciated. So I just go with the flow. Occasionally, something gets sold, for one price, I go along with, and it dribbles out a little bit. Last year, nothing, the year before a lot. You know, it's just money.
I think that one of the things that when Jarrett was speaking came to mind to me was that it's very important to make sure that the financial planners you're working with, the estate planning counsel that you're working with, divorce attorneys that you're working with, or domestic relations attorneys are aware of the other documents that you have, because financial planner may do something inadvertent with assets if financial planner is unaware of the fact that you have certain estate planning documents or a premarital agreement, which is going to mean that a transfer is meaningful and significant and can have very impactful consequences. So very important to not, I think that a lot of times what I see in my practice is that sometimes people enter into estate plan documents. They spend all that time and money to do things, premarital agreements, and then it simply gets put into a drawer and not thought about again, except for when the event occurs that triggers the document and they are not realizing any of the consequences of the many actions that they took over the years.
She had told our concerns all the time. But, you know, it was like, now we have a large portfolio with Morgan Stanley, and they said, if anybody wants to take a portion out, we all have to take equal portions out. Is that true?
Well, you could always journal it over to your own Morgan Stanley account, but that would be a distribution. All distributions have to be equal. Then
Okay,
yes.
so that, yeah. Okay,
Yes,
so
but you don't have to take it out, you just, move
letting
it,
it,
and I would suggest that you move it.
I would like to move it, but I have to have, their consent. It's not,
Without seeing the documents, I'm not certain that's accurate.
I thought it was kind of fishy, but.
Not necessarily it's fishy, just without seeing the documents.
Yeah.
It's
Not certain
it's-
that's accurate.
She's spent a lot of money with a different attorney to set up the estate, so. And then we have, I told you, Hallie and Swerve, so.
But
But double feet on them.
I find a lot of times, people set up estate plans and they made a lot of sense, and then 5 years later, if you were to try and map out what was actually supposed to happen, I don't think many clients could actually tell you. So, one of the things that we're trying to do here with this estate chart is really show you. So if you set up a trust, and then we can mimic, that event actually occurring, and we can see what's going to happen to your assets and how that Morgan Stanley account is going to flow through to, multiple next generations or children, or what's actually going to transpire, and be able to visually see. And I think that's extremely helpful for a lot of clients, because reading through legal documents, and read enough of them, and they're still terribly confusing for me, is important for clients to see that. And then, as they age or go through life, as things change with their situation, if we continue to do that on an annual basis,
Yeah, well, I was saying.
we make the alterations at that point.
One with my little sister's attorney, and my older sister married to an attorney here. And, I was just like, roof-strucken, and it was, I just can't get it for 3 years.
When do you get the adult children involved? So I know that everyone, including Jarrett, is going to say sooner than later. But when do you get the adult children involved when it comes to estate planning? So, mom and dad have done pretty well. They've got, $2 million. Kids are named as executor, but they don't know anything about what their responsibility is or what's going on. That's a good time to get them involved, truly involved in the process.
After the estate plan is executed, because I have found that the children have their own thoughts, and I don't want to hear their thoughts, to be quite honest. It's not their documents, it's their parents' documents. And I always ask, are there any concerns? Are you worried about any of your children? And if there's at all a concern, I always put an interim clause in my document, so that, look, you fight, you lose.
are some of the ways in your respective practices, whether it's assigning assets in a premarital agreement, designating assets in a trust, or titling assets in financial planning. We've heard about how we can protect assets from probate and also from ex-spouses. But what are some of the things you do to protect assets from taxes or to minimize tax effects?
Well, let me ask you this. At what income level do you pay the highest income taxes here in the state of Delaware? What's the highest income tax bracket here in the state of Delaware? $60,000. Yeah, that's our highest tax bracket. So, do you want to go into how to minimize income taxes?
With 3 minutes to go. There's a ton of different strategies, there's a ton of different strategies that you can go into to try and minimize taxes. Obviously, if things are in trust, to potentially pass that income out to a child who has a much lower tax bracket, where you're not going to be taxed at the trust tax bracket.
Kitty tax.
There's other components that you can look at from an investment strategy that may be federally tax exempt. Municipal bonds, for instance, that are federally tax exempt. If you can happen to find Delaware municipal bond, which are virtually impossible to get, then they're federally and state tax exempt too. So when we're talking about taxes, I know we didn't really hit on it from the estate planning side of things, and I think that there's a lot of different misconceptions about the death tax and what your exemption or exclusion limits are. Right now, I know that there was a significant amount of changes.
Yep, now
It
you
just
can make
recently happened.
$5.34 million free of federal estate tax and Delaware estate tax. Federal has a portability, so it's a combined tax between husband and wife. Delaware does not have portability, so it's 5.34 per person.
And since, we reside in a very small state, it doesn't take long, and I'm sure most of you have clients in other states. I know we do, Maryland, Pennsylvania, New Jersey. They're all subject to a different
Correct.
state tax component when it comes to inheritance tax and things like that. PA works very differently than Delaware and New Jersey's very general state, yes. So there's a lot of different components, and where you take residency is a big component versus when you're working versus when you're retired. How your retirement plan is actually impacted from a state tax level. So there are a bunch of taxes, and the tax code is extremely complicated, and it's not just one tax. When we say tax, I think everybody kind of just lumps it all together, and there's all kinds of different components: short-term capital gains, long-term capital gains. Now we have the surtax component, and then it's a tiered schedule based on your income levels. So.
Not really an estate planning issue, but I'm not sure if this is addressing your question or not, but basically in divorce, we can transfer everything tax-free. There are no tax consequences to assigning assets in divorce, and the recipient of the asset takes it at the basis of whatever basis it had during the marriage. That's the basis they take it at. We transfer retirement assets in divorce without and roll them over to another spouse without tax consequence. And sort of, I think, most divorce counsel are mindful of the fact that you want to make sure that you're prorating the assets or the holdings within the various retirement accounts, so that you're not taking all the low basis or high basis aspects of the account, so that there's a sort of level tax treatment between the divorcing parties.
How challenging is it when you've got to become like a mediator between husband, wife, other kids, where it's like they have different ideas and views as to what's going on, where this money should go, and how should it be? I mean, laws are laws and rules are rules, but when personalities and ideas get involved, I mean, how much of your time do you end up either babysitting or moderating?
A lot. A lot.
I think Beth spoke for all of us up here.
Yeah, I try to warn people that lawyers' hourly rates are a lot higher than a counselor's hourly rates. But the point, to Beth's point, though, part of our job is to listen and hear, and that helps impact what their goals and objectives are and how we create solutions for their legal solutions for their problems.
Beth, we've talked a lot about estate planning for couples. I know there's not much time left. Can you talk a little bit about estate planning for family businesses and what really is the most important thing that should be done first, second, third in those arenas?
I have quite a few, and I'm in Dover, so I have quite a few clients that have small businesses. And the question that I always ask is, do you think it's capable of going on to the next generation? Is there someone there that can run the business? Is there someone there that wants to run the business? Often I hear a no. And then, you're gonna have to consider selling. You can't really leave it. So there's a lot of things that can be discussed. Do ESOPs not too often? That does raise an issue though. Remember I told you that everything that goes through your will, other than real estate, will incur a probate fee. If I have a beautiful house down in Lewis and I pop it into an LLC, I've now incurred a probate fee. So there are ways to avoid that probate fee, but that's just another thing to think about. If you know who is going to take on the business, we can get the business to them. Then it's an issue of what's your basis now? Do you want to leave it to them in your will? Do you want to sell it to them? Do you want to give it to them? Now, each of them have different aspects related to it. Do you want to sell the business now? Do you want to enter into an option to sell the business? Do you have the 5-year S-corp difficulties? So it all depends. I run into all of those issues.
There's a new trend in real estate that are gifting out property, and it works out tax-wise that you end up with more money by gifting. You gift like stock portfolios, real estate, and it's charity, and it was part of the courses I took this last month. So it's a new trend, and it's kind of something that so it's a new concept.
We have time for maybe one more question, if anybody else. It's 4 o'clock, but it's gonna be late. Anybody else?
No. If not, please say thank you to Gretchen, Beth, and Jarrett.